B.W.S takes a objection to the entire process on the fundamental ground and principle that yes, the P.U.C has such a power, but any power is subject to law. And in this case, specifically the law in question requires that this be done only in exceptional circumstances. In other words, neither B.W.S nor the P.U.C can seek to invoke annual review proceedings with a view to lower or raise tariff unless there are exceptional circumstances. And the law defines exceptional circumstances. And no exceptional circumstances we say exist, and therefore there is no jurisdiction to have done what was done. So as simple as that. And secondly, that the natural rights of B.W.S were infringed because it was given absolutely no notice. In fact, we say that it was initially invited to do an IRP and it declined. And then the P.U.C simply went about, without notice, conducting an IRP. And we are now challenging their infringement of the law in doing so in the absence of exceptional circumstances. We are in fact challenging the entire procedure. We are saying you can't invoke this procedure unless there are exceptional circumstances, because we are still within the full tariff review period, which is 2015 to 2020. It has not yet expired. And yes, you have power to do an IRP or an annual review proceedings. It's actually annual, it's an interim review proceedings, okay. Right? IRP. And so we are not doubting their legal right to do so, but if you have a right given to you by law, the law also tell you what are the circumstances in which you can exercise that right. And we are saying they are not exercising the right they have based on the law, because the law says you do so if there are exceptional circumstances. It set out a few, and it says those circumstances must be outside the control of the licensee, B.W.S. And even after the fact, circumstances that they have alluded to are not exceptional, and they are not circumstances that are outside the control of B.W.S as distinct from outside the control of P.U.C.